官員入嚟啦，咁就等政府入嚟先得㗎啦。
Well, let's invite the administration in first.
開咗。
We have a quorum. Yes, I've called the meeting to order already.
好啊，咁啊，歡迎政府嘅官員啊。
Well, let me welcome the government officials. Matters arising from the previous meeting. At the previous meeting held on the 6th, the government, well, in relation to the Communications Association's views and the government's response, it's already tabled. Let's invite the administration to walk us through the paper. Well, the paper that we are discussing is CB bracket 1981/1415 bracket 2 in relation to some follow-up matters arising from the previous meeting. I'll go through the paper point by point and then I'll take questions from members. Well, last time, some members suggest or mentioned SVF under exemption in Clause 8 of the bill, and members ask how we can ensure that exemptions can be given under Schedule 8 of the bill. And according to Section 8ZZB2, it provides that the MA, the monitoring authority, may require the issuer or facilitator of the SVF to provide MA with any information that it considers necessary to satisfy the risk posed satisfying that the risk posed by the facility to the user are immaterial. So the monitoring authority can check the information to ensure that the risks are minimal and that exemptions can continue to be given. Another question on Section 8ZZZK, and that any licensee or any prohibited persons who are not licensees cannot hold themselves out as such licensees. However, the section doesn't cover the situation where a person makes a false claim of a third party as an SVF licensee, that is to be an SVF issuer or facilitator. And Section 8ZZZJ provides that the person must not publish an advertisement relating to the issue of an SVF unless the advertisement relates to the issue or facilitation of an issue of an SVF and that the license number is clearly stated in the advertisement. It will be an offense for the person who contravenes this requirement. And I understand that members and other stakeholders would like to make public the what are issued by the licensees, and according to the bill, the MA must keep a register of licensees for inspection by the public in the form of an online record, so that the public can check who are the licensees. And the SVF issuer must ensure that the license number is clearly stated on the physical device, the packaging containing the device, or the communication network concerned. That is to say, the website. These measures will enable the public to verify whether an SVF has been issued under a license granted by the MA. The third point relates to the legal advisor's comment in relation to legal professional privilege not mentioned in the bill. And as mentioned in the previous meeting, it is protected by Article 35 of the Basic Law, and nothing in the bill affects any claims, rights, or entitlements that would, apart from this ordinance, arise on the ground of LPP. However, to put this beyond doubt, we can draw reference to Section 81 of the Anti-Money Laundering and Counter-Terrorist Financing Financial Institutions Ordinance to make clear at this point. And we're going to propose a CSA, and when we come to discuss the CSA, I'll go through the details with members. Another matter relates to Section 33C and 33D in relation to the investigation provisions, and that the person under investigation will be required to provide information and the incriminating, and we understand that the incriminating information should not be acceptable or should not be admissible in evidence against a person in criminal proceedings. So we have also drawn reference to the SFO in the sense that the information that may tend to incriminate the person shall not be admissible in evidence against a person in criminal proceedings, except the proceedings in which the person is charged with an offense relating to perjury or the investigation. This is a standard provision which can also be found in provisions relating to investigations in other finance-related legislation. And there is also a empowering provision for the monitoring authority to impose sanction or disciplinary impose disciplinary action. And last time a member asked about the time limit for taking civil sanction. And we have drawn reference to the MPF schemes ordinance on similar provisions. We don't think there should be a time limit for the provisions for taking civil sanctions, because a former regulated person or a former licensee can still be subject to the MA's powers. Where there are reasonable grounds or where there are sufficient grounds, the MA may take civil action against these former licensees for the purpose of safeguarding public interest and the monetary or financial stability of Hong Kong. And we don't believe that we need to impose a time limit for the power to take civil sanction. And in para 8, it sets out the circumstances in which the tribunal may review the decisions of the MA. And the section provides that any person who is aggrieved by relevant decision of the MA may refer the decision to the tribunal for review. And Part 2 of Schedule 1 sets out a list of reviewable decisions. And last time, the Assistant Legal Advisor asked about Section 8A(2), in which the MA can declare that a person or a class of persons is not to be a manager or managers, and whether those persons or the person may be aggrieved. And we disagree, because if the MA declares that the person or persons is not to be a manager or managers, the class of persons or the person will not be subject to specific provisions regarding the supervision of managers, and will not fall in the scope of officers subject to sanctions. So the person will be in a more disadvantageous position if he or she is declared not to be a manager So we don't believe that we need to change this decision. And regarding 8ZV, on the MA's power to revoke the appointment of an advisor or a manager if their appointment is no longer necessary and will not cause any person to be aggrieved. And we've drawn reference to the similar provisions in the banking ordinance, and the situation is similar. We do not therefore intend to include the above two decisions in the list of reviewable decisions. But I want to emphasize that any person who's aggrieved by a relevant decision of the MA can be reviewed, and the decisions that may adversely affect the regularity have been included in the list. And Mr. Leung Sing last time also asked about some amendments in the Chinese text. We have considered these suggestions, and we're going to propose some CSAs, and when we come to the CSAs, I'll go through the details with members. And last time, Chairman asked the government to respond to a submission made by the Communications Association of Hong Kong, and we considered it carefully. In fact, Section 8C provides that any person must not knowingly promote or otherwise assist another person in issuing or facilitating the issue of an unlicensed SVF, including by means of providing network or internet portal access or other technological means. I want to emphasize that 8C doesn't impose any specific legal liability on, say, internet service providers or website operators to verify the contents and accuracy of the materials. And in 8C, we also set out in detail that the defense of a reasonable excuse available to such persons charged with offences. That is to say, if the person has not unknowingly promoted or otherwise assisted another person in the issuing or the facilitating the issue of the unlicensed SVF, the person will not be charged. And we have explained to members a number of times we're not going to amend Section 8C, and if necessary, the MA can issue the set of guidelines after the bill is passed, urging the relevant stakeholders to comply with the requirements. I think issuing guidelines may be more appropriate. For ISPs, to reassure ISPs. Any response, legal advisor? Thank you, Chairman. I have no other questions. I understand that there will be provision on legal professional privilege to clarify the issue. Any questions from members? If not, then we can move on to the CSAs. Now, in front of members, there is a paper in both languages, CB bracket 1981/1415 bracket 03, which is the CSAs. Incorporating members' suggestions and some of our considerations, and they will be moved by the FSTB, and perhaps I'll refer to the Chinese text when we go through the clause-by-clause scrutiny, and when necessary we can also refer to the English version. On page 1, clause 5 bracket 11, in relation to the definition of retail payment system. I recall that one meeting a member asked about retail activities, whether the retail activities refer to only to those taking place in Hong Kong, and this is not the case. It covers activities that take place in Hong Kong or elsewhere.
Therefore, we have included a bracket to state whether the activities take place in Hong Kong or elsewhere, to clearly set out the scope of the activities concerned. And also, since there is the word public in this proposed section, and in fact in other sections as well, for the sake of caution and prudence, we have particularly set out the meaning of public, and it states public means the public of Hong Kong and includes any class of that public. Any questions? Please continue. A big chunk of this paper is to respond to issues raised by the legal advisor. And for many offenses, we have listed the offenses for indictable offenses, and we have not included offenses and their penalties which attract summary offenses. And now we have put back the penalties for offenses under summary judgment or conviction. So let us look at section 6, bracket 3. And this is about the operator or settlement institution of the system having to give the MA the name, place of business, postal address, electronic mail address, etc. And the offenses are in subclauses 3 and 4. And then clause 14, it seeks to amend section 7 of the ordinance, requiring every system operator and settlement institution must keep rules of operation. And also, again, there will be conviction on indictment and summary conviction, and the offenses and penalties are set out. Legal advisor, have you looked at all these? Yes. Okay. The same goes for clause 7. This has to do with 8.0, section 8.0 of the ordinance. It says that the licensee must ensure that the operation of the SVF must comply with certain guidelines, and again, there is penalty set out for summary conviction. And then 8R1, this is in response to the Hong Kong Banking Association. This has to do with the operator of a SVF, which or who may no longer be able to do it, and he must report the matter to the MA. Since there is an identical section in the banking ordinance, namely section 67, if the bank sells SVF, however, if the bank can no longer discharge its obligations, then it can do so, or it can deal with the situation under section 67 of the banking ordinance. And therefore, we list here that this section does not apply to a licensee that is a bank. 8S is in the same batch. Again, the penalties for conviction on indictment and summary conviction. And then 8ZZZI, it requires all licensees which makes use of a physical device to provide SVF, then the license number must be present on the physical device, or that it must be clearly set out in the package. And also, if this is done network-based, this should be again set out clearly in the communication network concerned. To respond to members' questions last time, we have listed in subsection 5 the definition of communication network, saying that it includes a website of the licensee. And then after review, the administration provides or will provide a CSA under subsection 6. It reads, this section does not apply to a stored value facility that is a multi-purpose card issued under the banking ordinance before the commencement date of this section. What's the purpose? Under the banking ordinance, we have multi-purpose cards which are authorized to be issued, including octopus cards. After the amendment bill comes into operation, if we require the number also to be on all multi-purpose cards, then the banks would have to recall a big number of cards issued in order to put back the number on it, and it will cause chaos. Therefore, we have put in subsection 6 saying that if the multi-purpose card has been issued under the banking ordinance before the commencement date of this section, then they do not need to carry the license number. But of course, if the cards are issued after the commencement date of this section and all SVF issued, whether it is a physical device or whether it is network-based, they must carry the license numbers. In other words, once this section has come into play, then new Octopus cards will have to carry the number. Mr. Sin Chung Kai, there need not be any recall of the cards now. But they may already have a stock of Octopus cards, and if they were to add information on those, what kind of information are we talking about? PAS? Well, after the commencement notice has been issued, and if it requires a license, then even if they have a stock of Octopus cards there, they have to add the license number to those before they can be issued. Have you asked them what they will do? I don't know whether there will be difficulty for them to imprint further information on the cards that have already been manufactured. Well, we'll talk to them what they will do specifically. But right now, they understand there will be this requirement. And even if they have a stock of cards with them, they know that if they are to be issued after the bill comes into operation, they will have to think of a way to imprint the license number on those cards. We understand there shouldn't be a big technical difficulty. And allow me to add a point, Chairman. Under 1B of the same section, it says, if it is not reasonably practicable on the physical device concerned, we allow this to be done on the packaging containing that physical device concerned. So, Mr. Sin, if this is not technically possible, we can allow them to imprint the license number on the packaging, and so the public will know for sure that they have already got a license number. I don't expect any grave difficulties for existing suppliers. Legal advisor. The new subsection 6. Apart from Octopus cards, if banks issue other cards which allow online shopping, or they, in a way, are a physical device and at the same time they can be used online, so would you be exempting license numbers for online devices? PAS. Well, my understanding is that what the legal advisor said will not come to pass because under the existing banking ordinance, it only regulates multi-purpose stored value cards. In other words, the banking ordinance does not exactly monitor or regulate online or network-based stored value facility. So what you say will only apply before the bill comes into force. Therefore, what you pictured would not transpire. Well, they can, in fact, just update the web page with the license number added. Okay, if there are no other questions, can we carry on? Next, section 8ZZZJ. We have given consideration to members' questions in the first few meetings with regard to SVF issued outside Hong Kong and whether advertisements can be taken out in Hong Kong to offer those facilities. After considering members' views, we have rewritten 8ZZJ so that we can take care of what members asked. In subsection 1, we say a person must not publish in Hong Kong or elsewhere. Therefore, the applicability of subsection 1 will apply in Hong Kong or elsewhere. We say it should not, that person must not publish in Hong Kong or elsewhere advertisement, invitation or document mentioned in subsection 2A relating whether in whole or in part to the issue of a store value facility. And then we would ask that in the advertisement, invitation or document, there must be the licensee's number and also that this must relate to the tool of or facility offered by a licensee. Therefore, even if the public see this advertisement in Hong Kong, they must be taken out according to the requirements with regard to SVF under this ordinance, and there must be the license number of the licensee. Therefore, there will not be a question whether people will not be sure about whether the SVF is licensed or not licensed. And then under subsection 2, we say a person must not publish in Hong Kong or elsewhere an advertisement, invitation, or document mentioned in subsection 2 relating whether in whole or in part to the facilitation of the issue of a SVF. And we require that the license number must also appear in that advertisement. With regard to advertisement, invitation, or document mentioned in subsection 1 and 2, they must be issued to the public so that they are regarded as advertisement, invitation, or document under subsection 1 and subsection 2. This will protect consumers, and so the public will understand that the invitation is with regard to SVF provided by the licensees. If anyone flouts these requirements, they commit an offense, and then a defense is provided under subsection 4. If someone can prove that he carries on the business of publishing or arranging for the publication of advertisement, and if in the course of business he received the advertisement, invitation, or document, and he has reasons to believe that this person is a licensee or is exempted, then if he innocently contravenes subsection 1 and 2, then he will be able to use this as a defense. And with regard to publication, advertisement, and invitation and the definitions, we have again provided for these in this section. For example, publish. In relation to any advertisement, etc., it must be in a newspaper, magazine, journal, or other periodical publication. And then advertisement, it includes every form of advertising, whether made orally or produced mechanically, electronically, blah, blah, blah. And the same goes for invitation. We believe by amending the clauses this way, we'll be able to take care of members' queries, and that is whether extraterritorial people will be able to take out advertisements in Hong Kong. Anything from you, legal advisor and members? If not, please carry on. Clause 24, to amend section 12, and again to add the penalties for conviction on indictment and summary conviction. Clause 23, to amend proposed section 13.2a and 13.3. With regard to subsection 2, we cross out the words or the act or thing to be done. This is just for better styling. Because in subsection 1, we have talked about actions that are directed. And even if we cross out these words, there will be no prejudice done to subsection 1. And in subsection 3, again, penalties for conviction on indictment and summary conviction. Clause 27, to amend proposed section 30. The same thing. This is about penalties. Clause 28, to amend proposed section 31. This is about flouting the requirement to provide information. Again, penalties. Clause 29. This is a styling improvement. In proposed section 33J, a magistrate is empowered to issue a warrant authorizing the investigator to enter premises and to seize documents. We are changing the styling or writing of the clause. This will not impact upon the effect of the clause. We will just add the words specified in the information. And then clause 33, to amend proposed section 36. This is about the operation of the tribunal. If anyone flouts the order, notice, prohibition or requirement of the tribunal, etc., there will be an offence and there will be penalties.
定條例草案第45條亦都一樣嘅嚇，嗰個兩個程序。
Clause 36 is the same, and the relevant tariff will also be amended. Clause 37 and Clause 38 amends Section 46 and 47. And again, we have set out the tariff. Clause 40 enables the monitoring authority in Section 49 to make regulations by way of subsidiary legislation, which can only take effect after LegCo gives its approval by negative vetting. And the MA, when making regulations, should consult the Financial Secretary and the licensees of SVFs. This is pursuant to member suggestions at the meeting. Clause 41 amends Section 50 on LPPs. And again, we've set out the fine and imprisonment for conviction on indictment and on summary conviction. Clause 43 amends Section 52. Similarly, we set out the tariff for convictions on indictment and on summary convictions. Clause 43A is to be added after Section 52 in relation to the assistant legal advisor's comment on legal professional privilege and withdrawn reference from the AML legislation, and it provides that the ordinance does not affect any claims, rights, or entitlements that would, apart from this ordinance, arise from the ground of legal professional privilege. And subsection 1 does not affect any requirement made under this ordinance to disclose the name and address of a client of a legal practitioner. And this LPP provision is copied from other similar provisions, such as that in the AML legislation. And even without this provision, Article 35 of the Basic Law clearly provides such protection. Any question from the legal advisor? No. Clause 44 amends Section 53, and we have set out the tariffs for convictions on indictment and on summary conviction. And in the marked up copy, there is an error, Chairman. On conviction on indictment to a fine of $400,000 instead of $200,000, and to imprisonment for 2 years. And that also is shown in the original provision. And there are 2 typos here. So again, on conviction on indictment to a fine of $400,000 and to imprisonment for 2 years. And there is also the tariff for summary convictions. So Clause 52 amends Schedule 1 on reviewable decisions. And then we will come to talk about Section 8 in Schedule 3, Part 2, and any decision to give a prior permission is a reviewable decision. And as I mentioned before, a number of members, including Mr. Sin Chung Kai, Mr. Ray Chan, and Chairman, had expressed concerns whether the person using the SVF could retrieve the stored value or the deposit anytime he wants. And having considered the provision, we have decided to incorporate the Bills Committee's views, and that when issuing the SVF, the applicable company must redeem in full the total of the stored value that remains on the facility as soon as practicable after being requested by its user to do so, including the deposit. So if a fee and a charge is payable for a request for the redemption, The applicable company must, in the contract with the user, state clearly and prominently the amount of the fee in charge. And under some special circumstances, say if the store value facility is time limited or that it carries a memorative value, the MA must, on application of the applicable company, give a prior written permission for the SVF scheme not to be subject to Section 1. Otherwise, the applicable company must provide means for the user to redeem the stored value as soon as practicable. And according to subsection 3, where there is a prior written permission, we will still require the applicable company to stipulate clearly in the contract with the user, clearly and prominently, that the store value remained on the SVF is not redeemable after an expiry date, and also other terms or conditions relating to the redemption. And this proposed amendment should cover all circumstances to cater for the needs of consumers so that the SVF user can redeem the full stored value anytime they want. Mr. Sin Chung Kai, I accept this amendment. But I think the MA colleagues should understand this, that the MA should only give prior written permission under special circumstances, not as a kind of general practice. In general, under normal circumstances, users should be allowed to redeem stored value anytime. I understand it's difficult to make it clear in the provision, but I hope the MA will make it very clear this point when you speak on this bill during the resumption of second reading. Yes, we take your point. We will do so. Next, other consequential amendments. Clause 54. What about the wording in the Chinese text? Yes, Chairman, in Schedule 8, there is a list of SVFs under exemption. And at the clause-by-clause scrutiny stage, a member suggested that we translate digital products or such products as digital products instead of electronic products. That's the meaning carried in the Chinese text. And we are going to propose amendments accordingly. And there was also another amendment proposed by Mr. Leung Sing last time. We're going to delete the word yin in the phrase realizing the deposit in cash. Next is clause 54 in relation to banking business definition. The definition of banking business refers to the taking of deposit, which is a subject of regulation by the banking ordinance. And we provide that the taking of SVF deposit or float will not be amounted to carrying on a banking business under the BO, because it will be subject to regulation by this bill. So we want to make it clear that it doesn't cover activities other than definition of taking deposit. And also on clause 63, as we mentioned to members before, as the SVF deposit or the float is not regarded as deposit and it's not protected under the Deposit Protection Scheme Ordinance, we want to make it clear that such SVF deposit or float is not protected by the deposit protection scheme. They are not protected deposits. So we just want to make this point clear. As for clause 64, it is in relation to the Anti-Money Laundering and Counter-Terrorist Financing Financial Institutions Ordinance. Schedule 2 of that ordinance provides that for a store valued exceeding the amount of $3,000, customer diligence check would be required. And we provide clearly that be it the bank or the licensee in the future, if physical device is used and if the maximum stored value exceeds $3,000, then the customer diligence check will be required. So that's all for the government CSAs. Any questions, legal advisor? Thank you. Can the government confirm that for the tariff, apart from the convictions on indictment, there will also be a tariff on summary convictions? Any other questions from members? No? So that's all for our clause-by-clause scrutiny. Any proposed CSAs from members? No, not for the time being. So after the Bills Committee completes the scrutiny of the bill, would the government please tell us the timetable? We will consult the Secretary for FST to finalize the timetable. I believe we should be able to make it before summer recess of the LegCo. We should be able to resume second reading of the bill. And then if the scrutiny is completed, we hope to report to the House Committee as soon as possible, so that once the Council resumes in October, we can then propose this resumption of second reading and third reading of the bill. If there are further technical or consequential amendments, please circulate them for members' reference, and the Secretariat will make the arrangements. All right, any other business? If not, that's all. Chairman, on behalf of the other government colleagues, I thank members and I thank you for assisting us in the scrutiny work.